To Panel B's Medical Board of California meeting. We're opening our session at 10 a.m. for oral arguments. We have two, and the Honorable Adam Berg will be presiding over these arguments.
Thank you. Are you good for the? All right. Thank you very much. This, as noted, is the Panel B of the California Medical Board of California in the matter of Safwat Rizqallah, MD. It is case 800-2015-013514. Today's date is October 18th, 2018, and the hearing is being held in San Diego. Just before we continue, I want to make sure that the parties have consented to the electronic recording of these proceedings. Okay. Again, my name is Adam Berg. I'm an administrative law judge from the state's Office of Administrative Hearings. I'll be presiding over the hearing, but I am not a decision maker in the case. If the parties would introduce yourselves, please.
Deputy Attorney General Brian Bill on behalf of the complainant, and I am specially appearing.
I think you probably need to bring it a little closer.
Is this better?
Yeah.
Let me try this for a third time. Deputy Attorney General Brian Bill on behalf of the complainant, and I'm specially appearing on behalf of trial counsel Deputy Attorney General Tan Tran.
Good morning. Lindsay Johnson on behalf of respondent Safwat Rizqallah, who is present and seated to my left.
Okay, thank you. All right, each party will have 15 minutes to present opening remarks, as well as 5 minutes closing. The panel members may ask questions regarding clarifications for arguments, but may not elicit new evidence in the matter. So, Ms. Johnson, do you wish to reserve any of your time for a respondent to address the board directly?
No, Your Honor.
Okay. Do you want any cues for your 15 minutes? Or
If I can get 1 minute.
okay, I'll give you 1 minute.
Perfect.
All right, when you're ready.
Thank you. As this board is well aware, Dr. Rizqallah was licensed to practice medicine in the state of California in 1991. For the last 27 years, he has served the profession honorably. He has had no patient complaints. He has had no family complaints from any patients. He's had no supervisor complaints, and no facility that he's ever worked in has ever raised an issue with his practice. What Dr. Rizqallah has had, unfortunately, are several health issues. He is a lung cancer survivor and had a heart attack which resulted in surgery placing a stent in his heart chamber. And in addition, he suffers from degenerative disc disorder. These ailments are well documented. They've been clearly laid out. They're contained in his medical records. They are the result of other providers who have conducted thorough examinations, and they are the result of Dr. Rizqallah seeking various medical treatments far beyond simply seeking narcotics, but in addition, going for physical therapy, acupuncture, seeing various specialists, and then ultimately turning to his primary care physician who provided him prescriptions, all of which that have been well documented. In March of 2015, Dr. Rizqallah had the police visit his home following a domestic disturbance in his home. That police report indicates that his wife became upset during an argument and swung a hammer at his chest. At the end of that, there were no convictions, but Dr. Rizqallah was asked by the board to sit for an 820 exam, a physical and a mental evaluation, to determine his safety. He sat first for the physical examination, and he passed. The physical examiner found no concerns. He then sat for the mental evaluation, and during that mental evaluation, the result was a troubling report. Troubling for a couple of reasons. One, ultimately the conclusion in the report, which was certainly troubling to respondent, but two, the actual steps and the findings contained in the report, which by almost all accounts, including the administrative law judge who eventually heard this decision, were troubling, biased, and based on facts not in the record or in the evidence, nor presented by respondent during that exam. As a result of the 820 result, the board brought an accusation against Dr. Rizqallah's license. They alleged 5 causes of action, and we went to an administrative hearing on this matter. At the end of that administrative hearing, the proposed decision was issued, asking that Dr. Rizqallah's license, or recommending that Dr. Rizqallah's license be placed on 3 years of probation with various testing terms. These terms were a mimic, in some ways, of the terms already imposed on Dr. Riscala under an interim suspension order. And Dr. Riscala, since May of this year, has been complying with those terms, submitting 2 random drug screens that have been requested by the board and engaging in therapy. No concerns at any point have been raised. His drug tests have come back in a way that have completely kept him practicing, and his therapy has been valuable and has been submitted regularly to the board with no additional concerns. Background, which really just brings us to today. The board has considered the proposed decision, as it's well aware, and has decided to non-adopt. And so we move to the crux of the decision, and really what the decision contains. It is certainly respondent's position that he is safe to practice, but as one could imagine, that would be a respondent's position in general. So we look to actually the facts of this case. In Judge Goldsby's decision, or his proposed decision to the board, he found that the board did not in several steps, or complainant in several steps, meet its burden of proof in this matter. The crux of the board's concerns when it comes to Dr. Riscala was really twofold. One, that he was receiving high amounts of prescribed narcotics, and 2, that made him an opioid addict. In reviewing the evidence, Judge Goldsby, in our opinion, accurately found that complainant did not meet their burden in either of these instances. And this was found not only through the evidence itself, but through the testimony elicited at hearing. In order to revoke a license, a board must find by clear and convincing evidence that the evidence meets the standard necessary for revocation. So clear as to leave no substantial doubt. In advancing their written arguments, the argument has been made that circumstantial evidence in this case is enough, that if it's a logical conclusion or if it's circumstantial, then that meets the burden under Evidence Code 351. This is not true. In the non-adoption arguments, complainant writes that Evidence Code Section 351 says that all relevant evidence is essentially enough. In doing so, they've left off the first part of that statute, which is unless otherwise provided by statute. And statute is very clear that the evidence that is used must actually be there, that we cannot use administrative hearsay or we cannot use circumstantial evidence, but we have to actually find direct evidence that is clear and convincing. And in this case, that does not exist. Dr. Riscala received valid prescriptions from providers. These were the result of valid examinations. The medical records were turned over. He was seen a provider, examinations were being performed, various narcotics were prescribed, and these were all in correlation with test results that were also turned in. MRI reports, from his cardiologist, reports from his oncologist. His medications were in line and in correlation with the standard. And that's just not our perspective, but the perspective of the expert who testified in this case. There were ultimately 2 competing experts here. There was the expert advanced by complainant, who was found not to be credible by ALJ Goldsby, and there was the expert advanced by respondent, who by all accounts was found to be credible. In his expert report, Dr. Michael Sucher, when testifying in respondent's case, outlined for the board, in essence, through the transcript, his various examinations of Dr. Riscala. He outlined the meetings he had with them, more than one, the evaluations he performed, more than one, the review of the records, and concluded the same way that the physical examiner who was provided by the board in the physical examination concluded, that Dr. Riscala does not suffer from an opioid or substance abuse disorder. Instead, he found to the contrary. And his examination was, by all accounts, an examination that met the community standard. This, of course, is in contrast to the examination that was used as the crux of complainant's argument at the hearing. That examination started with a very troubling concern, where on the stand, Dr. Kirsten, the examiner advanced to support the complainant's argument at hearing, stated that prior to even meeting Dr. Riscala, he had already diagnosed him as a drug user and had already diagnosed him as an addict, based simply on the cures report. He was very clear in his testimony that prior to Dr. Riscala even entering the room, he had already made his diagnosis. And then he used the evaluation simply to fit other criteria into that diagnosis to substantiate it. This other criteria seemed to have a moving scale throughout his testimony, and it indicated a troubling concern with bias. For example, when discussing whether or not he believed Dr. Riscala had memory problems, something that he related to the at that point deemed abuse standard that he had found. He noted that Dr. Riscala scored a 28 on the memory exam. When asked what the good result was, he said 25. Now, Dr. Riscala clearly surpassed that, and yet the examiner continued to find fault in little details that he wouldn't find fault in elsewhere. And so it was these concerns that led to really the main concerns with the case that was advanced at the administrative hearing, which was, is the evidence there to support the idea that Dr. Riscala is in fact an addict? And the answer clearly was no. The only evidence advanced, that of the evidence of an expert, did not find that. It was advanced by an expert who was found to be biased, who was found not to be credible, and was counteracted by an expert who was found to be credible, who walked through the diagnostic examination, who walked through the DSM-5, and found that respondent did not, in fact, meet those arguments, or meet those criterion. Ultimately, that is, as I mentioned, the crux, it seemed, of complainant's argument, that Dr. Riscala was an addict, something that was not substantiated by the evidence. It then turned to the underlying second concern, whether or not there was negligence that happened in this matter, whether or not Dr. Riscala, when taking his lawfully prescribed prescriptions and then moving to practice that day as an anesthesiologist, whether or not this was negligent. It seems like there was some confusion, perhaps, over kind of the timeline of how this all occurred. Dr. Riscala testified that he took his medication at approximately 4 a.m. in the morning, and then would perform surgeries later in the afternoon at approximately 1 p.m. in the afternoon. His practice was set up so that he performed smaller surgeries, taking about an hour on average. This meant that there was a substantial window in between when Dr. Riscala was taking his prescribed medication and when he was serving as an anesthesiologist in surgery. During this window, there was ample time for him to evaluate whether or not there were any troubling or concerning side effects, something that never occurred. There was time for any other provider in the practice to observe whether or not there were any troubling or concerning side effects, something that never occurred. And there was time for him to evaluate the situation and decide whether or not another physician needed to step in for him, something that never occurred. We have seen for 27 years a practice completely free of patient complaints, completely free of supervisor or colleague complaints. For this idea to be advanced that he is a danger to the practice because he's on prescribed medication that could result in troubling side effects, we would have theoretically at some point actually seen these troubling side effects. And yet there is absolutely no evidence of that. And that is because, by all accounts, Dr. Riscala has been a very good provider. He has provided safely for the public. He has kept up to date. He has stayed in contact with his doctors to make sure that the medication provided for his continued health ensures the continued health of others. He has supplemented that with evidence that was presented at hearing of his continuing education that was primarily focused on opioid and various drug courses to show him that he is aware of the side effects, he is aware of the process, and he is aware of the procedure, and he would be aware if there were a problem. This evidence was important because it not only supplemented his evidence and his testimony, it not only supplemented the testimony of his expert, but provides that kind of third-party unbiased source. Ultimately, when deciding whether or not to issue discipline against a license, the board, we certainly recognize that public protection is of the utmost importance, and the board is designed and focused on whether or not the public is being protected. These proceedings are certainly not intended to punish a licensee, but instead intended to protect the public. But in making that determination, the licensee still has those rights, and when determining whether or not the public is protected, we have to see whether or not there is actually a danger at face value. Dr. Riscala does not present that danger. We can see that through his sustained history. We can see that through the lack of complaints. And perhaps more importantly, we can see that through the criteria that the board itself has advanced when considering whether or not somebody is safe to continue practicing. The California Code of Regulations provides us with that criteria, and it allows us to walk through almost a checklist to determine whether or not someone is safe. Dr. Riscala meets those elements to continue practicing. The nature and severity, the first criterion presented to the board for consideration, Dr. Riscala's medical history, the prescriptions that he was taking, although as I mentioned, he's been on an ISO and clean testing for the board for 5 months, so clearly is no longer presenting that danger, indicate that his medical severity does not impose on public safety. The second criterion, so the second and kind of the fourth criterion work hand in hand, which address criminal matters, and Dr. Riscala has no criminal convictions, so his criminal history and his compliance with criminal probation are not at play. We look at the time lapsed. So Dr. Riscala, when looking at his lengthy career, we can see a pattern not of danger, as was advanced in administrative hearing, but a pattern of continued safety practicing. And then finally we turn to the idea of rehabilitation, ultimately the crux of the matter. Case law has defined rehabilitation over and over for us again in a variety of different manners, but they all come back to the same underlying idea, the idea of somebody who understands the concerns but has addressed them and moved forward in a way that shows safety towards the public. And that's where the ISO terms in this, although initially contested by respondent, as one can imagine, play well into here, and it provides the board with an extra layer of reassurance. An ISO, an interim suspension order, was sought against Dr. Riscala in May. The ISO, despite the relatively low burden, was not outright granted, and instead Dr. Riscala has been allowed to practice, and subject to a couple of terms, one of which being continued testing. And this has really provided the board with
1 minute.
two extra layers of reassurance. It's provided the board with the fact that he's presenting clean tests, and so there's no concern. It's also providing the board with the reassurance that he will comply with terms imposed. Ultimately, these are not designed to punish the practitioner, and as ALJ Goldsby was very clear in his decision, anything more than the proposed decision would be unduly punitive. He says it outright. And so for those reasons, we respectfully request that Dr. Riscala be allowed to continue practicing with either the terms imposed by the proposed decision or those mitigated down based on the evidence or lack thereof. Thank you.
Okay. Thank you. Mr. Bill, do you want any time cues?
Yes, Your Honor, 1 minute, please.
All right, when you're ready.
Thank you. Your Honor, members of the board, this case is really about common sense, and the facts of this case call for a common sense approach. What is the common sense interpretation of the facts, and what is a common sense discipline based on the facts presented at trial? I think that approach is important in a case like this because this case doesn't fit into a typical box. It straddles different types of issues. There are elements of narcotics abuse, overprescribing, drug-seeking behavior, as well as dishonesty in this case. So I think it's important to take a step back and view this case as a whole. In this case, at hearing, it was proven that respondent regularly used opiates for approximately 5 years, between 2012 and 2017, present date actually, 2018. He received opiates from his sister, who's a medical doctor. The sister provided 19 pages of medical records that support her prescribing of opiates. Respondent also received opiates from his brother-in-law, a medical doctor. The brother-in-law also provided 19 pages of medical records to support his prescribing of those drugs. Respondent also was taking large amounts of other medications such as Soma, Ativan, Valium, and he received these prescriptions from his wife, who provided 12 pages of medical records, a psychiatrist, an independent psychiatrist who he saw for approximately 6 months, and once again from respondent's brother-in-law. The ALJ found that all of the prescribed medication from 2011 to about 2015 were prescribed without an appropriate examination. Additionally, it was determined that respondent regularly used Ativan and Percocet on the same day that he administered anesthesia to patients. The board expert, Dr. Kirsten, testified in this case. He testified that respondent was using high doses of Percocet while also using high doses of Ativan. Dr. Kirsten opined that this combination in this level is very dangerous for a person of respondent's age. Further, the ALJ found that respondent was unreliable, and therefore his testimony was disbelieved. The ALJ specifically found that respondent was defensive, that he denied objectively established facts that substantially impeached his credibility. He was found to not be a credible historian of his facts and his history. Essentially, the ALJ found that the respondent lied at hearing. The ALJ also found that there were multiple DV calls to respondent's home by local police, and that respondent was going through an acrimonious divorce. So I think when we take a step back and take a big picture view of everything that was presented at hearing, we have an individual who used multiple intoxicating drugs for at least 5 years, who used large quantity of those drugs, who used those same drugs before administering anesthesia at surgery, who obtained drugs from multiple providers. Those multiple providers were his sister, his wife, and his brother-in-law. Respondent had an unusually close relationship with his providers. I would submit to you, exercised a greater level of influence on the providers, on the prescribers of drugs, than a typical patient-doctor relationship. And I would submit to you that essentially that respondent was constructively self-prescribing. Essentially, he was, I would submit to you, a half a step away from prescribing to himself. By obtaining drugs from family members, I fail to see the distinction from self-prescribing. So I would submit to you that common sense says that a person with this combination of facts is at least dependent and likely addicted to the drugs that were prescribed. When you factor this use, his use of drugs during surgery, it's clear that respondent has a drug problem. And I would submit to you that it's the decision today is whether or not this is the type of provider that can be trusted to administer anesthesia to the people of the state of California. Now, based on the facts that were presented, I think common sense would dictate that revocation is the only appropriate discipline. In licensing revocation cases, discipline is based upon the charges proven at hearing and then can be modified either upward or downward based on the aggravating or mitigating circumstances. In the present case, there was no mitigation presented by the respondent. The ALJ, however, did find that respondent's compliance with the terms and conditions of the ISO, that was some level of mitigation. But I would submit to you that compliance with an ISO there's a clear analogy between that and compliance with successful performance on probation in reinstatement cases. And there's a case directly on point. It's in Ray Gossage, 23 Cal 4th, 1080. And that case held that since people have a strong incentive to obey the law while under the supervision of the criminal justice system, little weight is placed on that fact. Here, similarly, respondent had a strong incentive and still does have a strong incentive to obey the terms of the ISO, because if he fails to, very likely revocation will follow. Now, respondent argued in his moving papers as well as today that under CCR 1360.1 that various factors, that they've met various factors of rehabilitation. Specifically, respondent discussed the nature and severity of the act. Here we have heavy narcotic use, as well as benzodiazepine use, for a period of at least 5 years. This same use occurred while respondent administered anesthesia. So I would submit to you that the severity of this act is extraordinary when compared to other circumstances, other cases. There is no criminal record. I would agree with a respondent in that regard. However, there has been several police interactions regarding DV situations. The time that has elapsed, in this case, there's at least 5 years of heavy use, if not longer, versus 5 months of testing. That is hardly enough time to ensure that he's a safe practitioner. Compliance with other lawfully imposed sanctions, as I stated previously, respondent has been in compliance with the ISO. However, given the nature of the case law that's analogous, I would urge you to put little stock into that. And finally, evidence of rehabilitation presented by the respondent, there was none. There was no evidence of rehabilitation provided other than the 5 months of compliance with the ISO. The aggravating factors in this case, once again, there's the length of use versus period of limited use. We have at least 5 years of heavy use versus 5 months of negative testing. The amount of use is concerning. There was testimony that the respondent was taking such heavy doses of these medications that a person of his age could experience negative side effects. The sources of drugs is an aggravating factor. Here, once again, family members were the ones prescribing, and apparently who are still prescribing to him. And once again, because of that relationship, I think it makes it difficult for the family member who is prescribing to adequately monitor the use of the narcotics. Moreover, obtaining these drugs from family members really speaks to respondent's lack of self-awareness, as well as his evidence of his poor judgment. And finally, veracity. The ALJ essentially determined that respondent was not credible and that he essentially lied. So I think when you look at and weigh the aggravating versus mitigating factors, there's enough here to justify revocation. Respondent argues that compliance with the ISO would adequately ensure public protection. However, allowing respondent to continue in the same manner, obtaining narcotics from, or any drug for that matter, from family members, and allowing him to continue practicing, all this does is it ratifies the conduct that led to this case in the first place. The testing doesn't ensure that respondent is safely practicing. It doesn't protect the people of the state of California. And I would submit to you that based upon the facts of this case, it is clear that the terms of probation do not satisfy the board's primary purpose of public protection. And I would submit to you that the only way to ensure public protection is to prevent respondent from practicing. He needs to show an extended period of time of clean testing before he should be allowed to go back into the operating room. Thank you.
Okay. Thank you. Questions from the panel members? All right, Ms. Johnson, 5-minute closing.
Thank you. The idea of a common sense approach sounds nice in theory, but then we immediately fall to the question of who's common sense. And fortunately for us, we don't have to decide that. The court has already decided it for us. They have set out case law that has placed on the board the requirements that the board issue its own criteria and then be held to that criteria. And when boxes are checked, then the case does in fact fit in that box. Singh versus Davey held it most recently, but it goes back further. And because of that, we cannot take a common sense approach, but we have to take an approach of what does the law tell us. Something that was slightly concerning in arguments just advanced was this idea of Several times, it went back and forth on opinion, right? Essentially, Dr. Riscala was self-prescribing. He is likely addicted. These qualifiers, though, are not true, and they're not supported by the evidence. Dr. Riscala was not prescribing. ALJ Goldsby was very clear in his decision about that every prescription was obtained by another physician. In fact, Dr. Riscala was found to never have self-prescribed. And he was not addicted. This was found by the expert who was found to be credible in the matter. He did not meet the qualifications that were set out by the DSM-5. Much has been raised about whether or not Dr. Riscala's treatment by family members is of any importance of this case. But ultimately, the board has already set forth its opinion on family members treating other family members and has found that that is acceptable. If the board is to change its opinion on whether or not family members can treat other family members, then that's certainly something that's in its purview. But that's in its purview looking forward. Dr. Riscala cannot be punished for complying with regulations imposed on him at the time, which allowed family members to prescribe after valid examinations, which is exactly what occurred in this case. And it's important to note that the term family member technically applies to Dr. Riscala's brother-in-law. He's certainly married to Dr. Riscala's sister. But before that marriage, Dr. Solomon served as Dr. Riscala's chief resident. He was his supervisor and his trainee and his instructor before he was family. This was someone that Dr. Riscala went to because he trusted his reputation, he trusted his understanding, he trusted his education, and he trusted him as a provider. And this led to valid examinations. Another particular concern that was just raised is the idea that Dr. Riscala presented no mitigation or rehabilitation evidence, and that's not true. Dr. Riscala presented 6 exhibits at hearing, and he had witness testimony. This rehabilitation and mitigation should not be ignored simply because it doesn't fit into one side's arguments. He presented evidence of continuing education, he presented evidence of therapy, he presented evidence of a variety of different steps that he has taken in order to help reassure the board. And he has presented evidence of his compliance with the ISO. We certainly recognize in re Gossage as established law, but in re Gossage applies to whether or not somebody is under the watchful eye of the criminal justice system, and therefore their compliance should be taken with less weight. That does not apply in Dr. Riscala's case. In fact, the same agency that decided in re Gossage, the State Bar, several years later came out with in re Bodella, which found that Gossage is not applicable to those outside of the formal justice system or the formal criminal justice system. And Dr. Riscala has no criminal convictions. He has never been under the watchful eye of the criminal justice system, and therefore his compliance with the ISO should serve as additional reassurance to this board because it's the exact same board he would once again comply with if placed on board probation. And it's that reassurance that we believe is important. A lot has been made of Dr. Riscala's character, but that making of his character has gone multiple ways, and we've seen how it's been used and twisted against him. For example, okay.
1 minute.
Oh, I'm sorry, I thought you said time. We just heard that he should be looked at disfavorably because the police have come out multiple times to his home. Reading the police report, it's clear that Dr. Riscala was not the aggressor in these matters. When looking at the prescriptions provided to him, it was clear that he was not self-prescribing. It's clear that he does not have the addiction. We can certainly, it's hard sometimes to fit things into boxes, I agree with that. But when the evidence is there, when the rehabilitation considerations are present, and when we are looking at the checklist and we can see that Dr. Riscala is a safe and practicing provider who has been safe and practicing for years with no concerns, and more importantly, when we see that complainant has not met the burden that is placed on it by statute, to impose discipline and even additional discipline is both unwarranted, barred by the courts, and in this matter, not intended or will not advance in any additional public safety. Thank you.
Thank you.
In this case, respondent was found to have violated the gross negligence, repeated negligent acts statutes 2234. And that was based on respondent's use of these dangerous drugs while providing anesthesia. He was also found to be in violation of 2239, the misuse of dangerous drugs statute. Given the facts of this case, that alone, the fact that he used these dangerous drugs and then went into the operating room and put people under anesthesia. That alone is enough to justify revocation. But when the evidence shows that he's done this over and over and over again, likely for years, and now he has 5 months of clean testing, I think when you weigh those two, the board has to revoke respondent's license. The people of the state of California should not bear the burden of the risk that he could be under the influence or taking these dangerous drugs and then proceeding into the operating room. That is not fair for the people of the state of California. The only appropriate remedy in this case is revocation, and I would ask that the board revoke respondent's license. Thank you.
All right, thank you. That concludes the arguments in the matter. The board panel will now meet in closed session and deliberate. Thank you to both parties.
Still in the morning. Good morning, everyone. Welcome to Panel B of the Medical Board of California's meeting, October 18th at 2018. It's 11:08, and we'd like to call this meeting back in order. And we would like to move to panel number 2 on our agenda, the election of panel chair and vice chair. Do we have any nominations?
I nominate Christina Lawson to another term of chair.
Second.
Okay, all in favor?
Mind repeating that? Mind repeating? I was not able to hear anything what you say. Would you select? Sorry about that.
Ms. Christina Lawson has been nominated and seconded as chair of Panel B.
Okay, all in favor?
Aye.
Okay, unanimous.
I nominate Michelle Bollard as the vice chair.
Second.
All in favor?
Aye.
Unanimous. Thank you very much. And today we have the Honorable Adam Berg presiding over our oral argument of Margaret Sprague. Thank you very much.
Wasn't me. All right, thank you. This is the oral arguments after non-adoption in the matter of Margaret Melinda Sprague, MD. It's case 800-2016-028-304. Again, today's date is October 18th, and the hearing is being held in San Diego. The parties just want to make sure that you both consent to electronic recording of these proceedings.
Yes, Your Honor.
Yes.
Yes, Your Honor.
All right, thank you. If the parties would like to introduce themselves, please.
Giovanni Mejia, appearing on behalf of the Office of the Attorney General.
Good morning. I'm David Balfour here with my client, Margaret Melinda Sprague.
Okay, thank you. The parties have 15 minutes to present opening statements as well as 5-minute closing arguments, in between of which the panel members may have questions on the arguments. Mr. Balfour, did you wish to reserve any time for your client to address the board directly?
Yes, I would.
Okay. Do you want to give you a time limit, or how would you like that done?
I think I'm going to be real brief here, and then I would like to turn it over to her. And my understanding is you'll swear her in at that point.
That's fine. Actually, if she's going to speak, I'll just swear her in right now. If you would raise your right hand, do you swear or affirm the testimony you'll be giving will be the truth, the whole truth, and nothing but the truth? Just because we are electronically recorded, when you do speak, make sure you're sort of straight into the mic. All right, Mr. Balfour, your 15 minutes will begin now.
Thank you. Thank you, Your Honor. Thank you, members of the board, for your time and attention this morning. Per the notice from the board, I'm going to direct my remarks, as I said very briefly, to whether the penalty is appropriate on this case. ALJ Hewitt did conclude by clear and convincing evidence that petitioner presented evidence of rehabilitation sufficient to warrant the reinstatement of her license. I do think there's sufficient overlap those issues. So the first is Miss Sprague is an admitted addict. She had an addiction to cocaine, and we presented evidence at hearing that's in the record of how she is in recovery. She's in 12-step recovery. We presented evidence in the record of continuous negative urine screens from the date she submitted her application, which was November of 2016, through the date of the hearing in June of 2018. We presented testimony of her sponsor, a Dr. Andrea Bauer, who is someone she met in the board's diversion program many years ago, before her license was revoked in 2005, and who became her sponsor over the last several years. We also presented testimony of her lifelong friends, some of whom are in the courtroom to support her today, as well as her daughter, Melinda Bruns, all of whom testify to her sobriety and cleanness ever since the date of her revocation in 2005. Petitioner similarly is going to tell you more about that. There was also an issue in terms of her depression, and petitioner testified at the hearing regarding a consultation that she got in 2006. So after she was off of cocaine, and she was directed to use Parnate medication for her depression, which she has used ever since then, and she's been stable in her depression. And once again, her lifelong friends, her family members, and others testified to her stable mood. The final issue, given that her revocation was in 2005, is her competence. And we presented evidence at hearing that she's accumulated approximately 200 CME units since 2013. And perhaps more importantly, she voluntarily went to the UCSD PACE assessment, and she initially didn't complete that. They had some recommendations for remedial steps for her to take. And she took those steps, and then they passed her subject to some recommendations. Those recommendations included that she practice only psychiatry, that she have a practice monitor for 3 years of practice, and that she not engage in solo practice. And the practice monitor and the no solo practice are recommended terms by ALJ Hewitt as part of the order. And she will tell you today her only practice before was psychiatry, and that is her intended practice should the board permit it. With respect to the other terms that were recommended, all of the alcohol and drug terms were recommended, including a chemical dependency evaluation. And I anticipate the AG's office is going to argue about lack of evidence of depression. I think the ALJ at the hearing was very clear from the testimony that was presented by those who know her best that her mood has been stable. But the petitioner testified that she would be more than willing to have a psychiatric evaluation or engage in psychotherapy. The chemical dependency evaluation, is my understanding from experience, I believe the board has the same experience, is that is performed by a psychiatrist with some specialty in addiction. And for someone who is an admitted abuser of cocaine years in the past with mental illness issues, that would be the ideal person. Ms. Sprague is, as I said, willing to have that evaluation and follow any additional terms that might be recommended as part of that chemical dependency evaluation. And with that, I think I'm going to turn it over to my client to tell you a few remarks directly.
Okay, 10 minutes on the dot remaining.
Excuse me?
You have 10 minutes.
10 minutes. Okay, thank you. And thank you for your time this morning. Good morning. My name is Melinda Sprague. Mr. Balfour felt it was important that you have the opportunity to hear from me directly. Given my history of cocaine addiction and chronic depression, I would, of course, be happy to submit to any evaluation the board deems necessary to ensure I am safe to return to practice at this time. Additionally, I have no problem with the terms of probation Judge Hewitt wrote in his decision. For example, continued biological fluid testing, recovery meetings, worksite monitor, a practice monitor, prohibition from solo practice for 3 years, and of course, abstinence from alcohol and controlled substances, to name a few. I also understand the board would probably prefer that I be under the care of a psychiatrist. I wish to ensure the board that I have a stable support system for my sobriety. Many of my family members live in the San Diego area. My most important family member and most ardent cheerleader is my daughter, Lindy, who resides in New Orleans with her husband. I also have lifelong friends, some of whom are here, and I've known them since junior high. And my addiction, unfortunately, caused great pain to my friends, and I would never subject my friendship to that sort of strain again. I attend a small professionals recovery group on Wednesday night, and some of the members are here as well. And I derive great support and knowledge from my fellow members. I also attend a Cocaine Anonymous group every Friday night. My sponsor, Andrea Bauer, has and continues to be a constant and important source of support. She has provided guidance and level-headed advice for the 4 years I have been with her. My mentor, Dr. Milner, has provided a model for a psychiatrist in long recovery and the valuable services he provides. I have been free of cocaine since the revocation of my license in 2005, and I'm very grateful for my sobriety every day. In 2006, I sought help from a well-known psychopharmacologist, Dr. Stephen Stahl, because I had had little success in obtaining relief from my depression. He informed me I had a treatment-resistant depression and suggested I try Parnate, an MAO inhibitor, an older drug seldom used today. It has worked well for me, and my depression has been in remission since then. After losing my license, I involved myself more with my mother and her care for her advancing Parkinson's disease. I was also caring for my older husband with congestive heart failure. I was able to spend quite a bit of time with my mother before her death in August of 2013. My husband died soon after in January of 2014. I also did some volunteer work along the way with Voices for Children and helping children get adopted before they get into the foster care system, because I had experienced as a psychiatrist for the county that the foster care system isn't really designed well for children. So I volunteered with them. As to current competence in psychiatry, in 2014, I attended 2 psychopharmacology courses to get an idea of what was new in psychopharmacology. And even before I submitted my petition for reinstatement, I requested an evaluation from the PACE program. I knew it would be essential for my petition. More importantly, however, it was important for me to find out where I needed to enhance my knowledge in order to return to practice. They recommended a board review course and a psychopharmacology update course, both of which I completed. In 2017, I completed the PACE with a passing grade. In 2018, I earned 111 CME credits from online activities. Judge Hewitt's orders include additional educational requirements, which I look forward to completing. As I sit before you today, I have a fairly unique set of qualifications. I am a female child, adolescent, and adult psychiatrist in recovery. According to the American Academy of Child and Adolescent Psychiatry, there are only 8,300 practicing child and adolescent psychiatrists in the whole nation. It does not, of course, have a number for those in recovery, but I know of only one other psychiatrist in the community with child training who is in recovery, and that is Dr. Milner. Having now heard countless stories of addiction through attendance at 12-step meetings, I know many addiction stories begin in childhood and adolescence. I plan to use my experience as an addict and my expertise as a child and adolescent psychiatrist to prevent children and adolescents turning to drugs and alcohol to treat their anxiety, depression, trauma, and other disorders. As a female psychiatrist, I already have extensive experience in treating women with PTSD secondary to sexual trauma, as my former practice was easily 40 to 50% composed of such women. With the advent of the Me Too movement, many women are coming forward to be treated for the trauma they heretofore suffered in silence or treated with drugs and alcohol. In the future, as a psychiatrist in recovery, I will be a valuable resource to other recovering physicians in need of psychiatric care. My depression went hand in glove with my addiction. If I can help other physicians avoid my fate through prompt and thorough care of any concomitant mental illness, my experience will never be all for naught. These are just a few of the unique perspectives that I bring to my potential practice of psychiatry today. Thank you.
Thank you. Mr. Mejia.
Thank you, Your Honor, members of the board. As I'm sure you are reminded all the time, the board's highest priority in carrying out its licensing and regulatory functions is protection of the public. Now, I raise that because it's particularly relevant in the instance when the board's considering a petition for reconsideration, because given that public protection interest, the burden's on petitioner to show by clear and convincing evidence that she is indeed rehabilitated. Now, in the context of substance abuse, the board's inquiry is made even more challenging. Several factors and several elements of a person's background and history can play into how pervasive an issue their history of substance abuse is, but also the board has to try to evaluate, based on the information presented by petitioner, what the likelihood is of reoffending in the future and what kind of danger they might pose to the public if they're allowed to practice. Now, I posit today respectfully that the proposed decision in this order wrongfully concluded that petitioners put forward clear and convincing evidence of rehabilitation. In particular, I'm going to point to major questions regarding the nature of petitioners' purported rehabilitation, as well as certain credibility concerns that arise given those gaps. Now, in order to paint you a full and appropriate picture, I think it's important to touch quickly on just how pervasive Ms. Sprague's substance abuse issues were at the time her license was revoked in 2005. Within the board's records, you have what's Exhibit 4, which is the decision that the board issued back in 2005. Among the board's findings were that petitioner was in fact addicted to cocaine, that she had made numerous unsuccessful efforts at rehabilitation, and that she had an unwillingness at the time to take responsibility for her actions. The testimony in the instant hearing also recounted just how pervasive petitioner's substance abuse was. Nancy Ivey, a childhood friend of petitioner, testified at hearing that she actually took the step of preparing a letter terminating their friendship because of how pervasive Ms. Sprague's substance abuse issues were, how unreliable and erratic it made her. Petitioner to herself testified that she had daily cocaine use during that period in the late 90s. Further, she testified about relapsing after going to intensive rehabilitation programs, in some cases 6-month programs, in some cases week-long programs. Finally, she testified that she used to utilize cocaine to self-medicate for depression. And so it comes as no surprise that depression is a central component of the rehabilitation narrative that petitioner has put forward. And the evidence of rehabilitation is one of the factors the board is specifically directed to look at when evaluating petition for reinstatement under Business and Professions Code, Section 2307, as well as Section 1360.2 of the board's regulations. Now, the board has before it in Exhibit B a narrative statement that petitioner included with her petition for reinstatement. Therein, she notes that depression was a major factor in her cocaine use, and she notes that she's currently in remission from depression, and that's part of her relapse prevention. In providing more information regarding that purported remission, she notes that she's in weekly therapy with Dr. John Milner. She repeated this claim in a June 2017 interview with a board investigator. She specifically referred to Dr. Milner as her treating psychiatrist. And I can refer the board to Exhibit 8, which is a transcript of that interview with the board investigator. At page AGO 0141, she specifically labels him her treating psychiatrist. Further in that discussion, the investigator, reasonably and appropriately, asks the petitioner to provide a release for her medical records. Again, depression is a major component. Depression and management of that depression is a major component of her rehabilitation narrative. It makes all the sense in the world that the investigator would seek out those pertinent medical records to gain greater insight into the extent of rehabilitation, if any. Now, at that moment, petitioner had a chance to clarify her relationship to Dr. Milner, if in fact he was not a treating physician in any capacity. She had a chance to point the board's investigator to those persons, if any, that were actually providing her treatment for depression or substance abuse or any other issues. She didn't do that. She executed a release for medical records for Dr. Milner. Exhibit 6 in the records before the board is a certification of no records that Dr. Milner provided. And the reason he provided a certification for no records is that he was not her treating psychiatrist. Rather, Dr. Milner testified at hearing that he was contacted by petitioner and brought on to help her with the process of reinstatement and reentry into the medical profession. And that's fine that he was in a consulting function, but that already presupposes that his role is to assume that petitioner is ready to be a licensed physician again. And this is important because at hearing, petitioner did not offer any clinical or evaluation, any clinical practicing physician that could provide an objective assessment of her current mental health, as well as her management of her substance abuse issues. As I've already pointed out, Dr. Milner's testimony is not reliable on that front. Petitioner did offer the testimony of another physician, Andrea Bauer, but she's her sponsor in her caduceus program. And further, Dr. Bauer specifically noted that she's never been a treating psychiatrist for petitioner. Her other witnesses were her daughter and a childhood friend who, while being able to provide insights about certain observations they've made regarding petitioner, cannot provide any reliable clinical assessment or insight regarding her management of her depression, regarding her management of her substance abuse issues. So in effect, the board is left with an absolute void of evidence that can corroborate her claims as to the management of her depression and as to the management of that depression being a key part of her relapse prevention. Now, petitioner did submit a one-paragraph letter from a physician named Carla Fox, which at hearing for the first time, she stated is currently her primary care physician. But that letter contains no history regarding petitioner substance abuse. It provides very superficial insight as to the status of her current depression. And it goes into no details regarding the extent of their relationship and the extent of her current management of any mental health issues. Now, secondarily, aside from leaving the current matter without any objective medical assessment that the board can rely on, petitioner's mischaracterization of Dr. Milner's role in her rehabilitation puts her credibility at issue. And that's also a proper consideration for the board pursuant to Section 2307 of the Business and Professions Code. And I'll go off on a side tangent here to point out that assuming petitioner had put forth clear and convincing evidence of rehabilitation, that credibility issue casts serious doubt over whether any probation terms can actively protect the public from the risk of relapse. The various terms of the uniform standards, a practice monitor, group therapy, they all to some degree rely on the candor of the person undergoing that therapy, of the person attending those group sessions, of the person who's meeting with a practice monitor. Further, it's worth noting that in the original 2005 decision of the board had no confidence that petitioner was telling the truth in her testimony in that proceeding, or that she had remained sober since 2002, as she claimed at that proceeding. And that's in Exhibit 4 on page AGO 0035. Further, the board's findings in that matter noted that at least one instance, petitioner had in 2002 attempted to fake a urine test. It's also in Exhibit 4 on page AGO 0031. So petitioner came into this proceeding already with some credibility issues from the initial act that resulted in the revocation of her license. The mischaracterization of Dr. Milner and her role in her purported rehabilitation now resurfaces those concerns. And to the extent the board is inclined to consider any kind of reinstatement of her license and apply probationary conditions to that, casts serious doubt over the efficacy of those conditions to protect the public. But returning to the big picture question of whether petitioners' instant petitions should be granted at all, it also calls into doubt whether the board should take her on faith on various other elements of her reinstatement. So for example, petitioner points to the fact that she submitted biofluid testing letters and printouts. Now her sobriety monitor in that regard, Ann Glassmore, was not called to testify in the instant hearing. And yet those letters themselves point out to certain irregularities in the biofluid testing, including a test in December of 2006 to 16, as well as a test in January of 2017. I refer the board's attention to Exhibit D for that. Now, Ms. Glassmore wasn't made available to testify to provide elucidation on that, other than those statements which came in as administrative hearsay. Further, petitioner herself testified that prior to June 2016, she had submitted to sporadic biofluid testing, but it wasn't consistent because of financial difficulties and financial issues. Again, we're left with nothing else but petitioner statements to corroborate that. And so really at the end of the day, what this instant proceeding presents is petitioner is asking the board to take on faith that she is effectively managing her depression. Again, no treating physician testified in this proceeding. No medical records were submitted in this proceeding for petitioner. The board is asking, petitioner is asking the board to take on faith that she has been in fact sober since 2005. Of note, to the extent Ms. Glassmore, who wasn't called to testify, but submitted certain reports for testing, none of the witnesses that actually did testify testified that they had actually reviewed those toxicology reports. Not even Dr. Milner, who was providing her advice and consulting on the reinstatement process. Not Dr. Bauer, who was her sponsor in the Caduceus program. And so, given that petitioner in this matter bears the burden of proving by clear and convincing evidence that she is in fact rehabilitated, her indication that she's willing to accept ongoing psychiatric treatment, her indication that she's willing to submit to a clinical diagnostic evaluation is welcome. But the problem is that information regarding her current health state and her current substance abuse issues or management thereof, that all needed to be made available to the board already as part of the petition, as part of the hearing in this matter. Finally, to the extent, again, the board is inclined to entertain whether to reinstate petitioner's license. I note that petitioner has made arguments regarding the outstanding investigation and administrative costs recovery amount in the board's 2005 order. And just by way of quick reference, in 2005, the board ordered petitioner to pay over $25,000 in investigation and administrative costs at the time. Now, I would point out that the order was issued appropriately. It's a proper order. It was issued when the board, in fact, had the authority to make such recovery amounts as a condition of any order. I think to the extent the board is entertaining reinstatement, it would be entirely appropriate to seek recovery of that amount. Notably, in 2006, when the statute was changed so that the board can no longer recover those amounts, that change was made in the context of then redirecting or recovering those funds from general licensing fees for physicians. That is to say, renewal fees, initial license fees, as opposed to through the disciplinary process.
1 minute.
In this case, petitioner benefited from the prior regime where the licensing fees were reduced on the understanding that fees were going to be recovered through the enforcement process. So I think it would be absolutely consistent with the law, which itself has no indication that it isn't meant to apply retroactively, to include that some kind of payment plan as a condition of petitioner's reinstatement. However, I fall back to my original position that simply stated petitioner has not put forth clear and convincing evidence of rehabilitation, that her mischaracterizations during the process of filing the petition and the board's investigation cast serious doubt. One, as to her current state regarding substance abuse issues, and then two, the likelihood of success of any probation conditions protecting the public. Thank you.
All right, thank you. Any questions from the panel members? Okay, 5 minutes closing remarks. Mr. Balfour.
Thank you. And once again, I'll be brief. I think you heard directly from my client this morning that she is an admitted addict. She's come right before you and told you straightforward that she was an addict and that she's in recovery. There was a poignant moment during the hearing when the friend, Nancy Ivy, that was referenced to, had written her a letter saying, "I can no longer be your friend because of your addiction," came to testify. And that really is all this board should need to hear from lifelong friends since junior high, that they separated from friendship, but now it's been restored. And that was the testimony throughout, including from her daughter, including from another lifelong friend, and then from her sponsor, was the extent to which she is committed to her recovery and grateful for her recovery. With respect to the depression, again, you heard here today how she, after she was off of drugs, she was able to get the medication to appropriately address her depression. And we once again heard from the friends and family members who could attest, yes, they're not clinicians, but they could attest to her mood being stable from that point in 2006 forward. They were prescribed by her primary care physician, and they worked. But once again, Ms. Sprague is willing to have a psychiatric evaluation either independently or as part of a chemical dependency evaluation, so that a psychiatrist appointed by the board can make a determination with respect to the status of her depression and whether any additional measures need to be taken. We heard very little from the Attorney General's office in terms of appropriateness of the penalty, kind of with the suggestion that there's no penalty that could be appropriately monitoring her. But I think her history from 2013 forward of trying to regain her license, of voluntarily going to UCSD PACE for the assessment with all the expense that's involved there, with undergoing consistent, continuous urine screens from November 2016 to the present, and all the expense that is there. her actions speak very loudly that she is willing to comply with the order of the board. And I would submit that the recommended measures from ALJ Hewitt are sufficient, but in the event the board feels that additional psychiatric evaluation or psychotherapy are required, Ms. Sprague testified at hearing, and she told you again this morning that she would be willing to do so. Thank you for your time.
Thank you, Mr. Balfour. Mr. Mejia.
Thank you, Your Honor. Certainly, petitioner had lifelong friends and her daughter come to the hearing and testify on her behalf. And these are individuals who were deeply affected by petitioner's history of substance abuse. But their closeness to petitioner in and of itself makes it difficult for this board or any independent body to rely solely on representations from those individuals and petitioner to conclude clearly and convincingly that she is in fact rehabilitated from her substance abuse issues. And so it's in as much as there is no appropriate penalty to guarantee public protection here, that's informed because petitioner put the board in that position when she didn't provide candor and didn't provide full disclosure of a current treatment situation throughout the petition proceeding. I think it's further the absolute void of any medical records, of any testimony from a treating physician or an evaluator with any expertise in substance abuse issues in that treatment or evaluation capacity puts the board in the position where they can't have any confidence clearly and convincingly that a certain set of conditions will in fact protect the public going forward. And so I think that's really the crux of the present issue. I think that's really the crux of petitioner's effort to try to modify the pre-existing penalty, and I think further that it really makes clear that it is within the proper scope of this proceeding to consider, are there any parameters under which the board can reinstate petitioner's license based on the information she provided, and more importantly, based on the information she didn't provide. Thank you.
All right, thank you very much. That concludes the oral arguments in this matter. The board will meet in closed session to deliberate. Thank you to both parties.
Thank you.
Thank you.